And Judge, I am on standby on Mr. DeBus. Although
Oh,
I'm
that's
not
fine.
attorney of record, I will be standing by though.
All right, and that's what I'm going to call now because it looks like it's between Mr. DeBus and Mr. Cochran. Well, I can't call, yeah, Mr. DeBus, you want to start your video? Okay, we are back on the record in 2023 TR 2777, State of Kansas versus Anthony Edward DeBoose, with Jared Regier for the state, Mr. DeBoose in person, and with standby counsel Darren Patterson. Standby because my prior contacts with Mr. DeBoose led me to believe that he, even though he wants to represent himself, there's much about the legal system that he doesn't know or understand and would need the benefit, or would certainly benefit, period, from Mr. Patterson's representation. So, Mr. DeBoose, at this time, you want to talk to Mr. Patterson and take advantage of his knowledge and experience in the legal system concerning this no driver's license charge, registration, and insurance violations.
Let me ask first, are we on the record? Is there a court reporter present?
Is there a court reporter present? This hearing is live. It is being recorded. Is someone sitting here with their little fingers clicking across the keyboard? No.
So you're saying that this is not currently...
Welcome back to channel where real-life drama meets legal reality. Today, we're in Kansas for a showdown that's become all too familiar. A self-proclaimed sovereign citizen facing off against Judge Phyllis Webster, a no-nonsense judge who's quickly gained a reputation for a calm yet commanding presence. Our defendant, Anthony Deuce, insists that the state of Kansas is some sort of corporation and that he, as a private man, doesn't fall under its jurisdiction. But Judge Webster isn't buying it. Not for a second. This hearing starts off relatively calm, but quickly slides into a fascinating mix of legal confusion, misplaced confidence, and patient judicial school.
Because this is being recorded, subject to transcription at any time.
Okay. I would ask for a copy of that transcription.
Well, when you file a written motion and pay the transcription fee, sir, that will be arranged.
Okay. And Phyllis Webster, will you please recite your oath of office into the court of record then today?
No, sir, I will not.
Why are you refusing to do so?
Let's move along.
I would please like to have that question answered. On another note, I am appearing specially, not generally, under threat of duress and further coercion by the state of Kansas court.
I did take my oath when I was appointed and when I was elected subsequently. Now, what is it I can help you with today? Do you want a trial, a jury trial, or do you want to enter a plea today?
It seemed like last time we had court, you entered the plea for me.
I did, because you would not.
Okay.
But yet what you were saying suggested you wanted a trial, so I entered the not guilty plea and set it for trial. Somewhere along the line, you led me to believe you wanted a jury trial as opposed to a bench trial.
Here we go. The classic sovereign citizen starter pack. Questioning whether the court is of record. This is a tactic often used to derail proceedings by pretending that technical wording invalidates jurisdiction. In reality, every courtroom operates as a court of record, meaning all proceedings are logged and preserved, whether by a stenographer, digital recorder, or both. When Deuce demands to see someone typing with their fingers, he's missing the point entirely. A court of record isn't about the method, it's about the preservation of evidence. Judge Webster's calm reply here is a masterclass in patience. She doesn't take the bait. Instead, she keeps the focus where it belongs, the actual case.
Had I been making the decision, I probably would have said bench trial. But somewhere along the line, you've made comments to make me think you wanted a jury trial. Now, I have not seen, let me double check. I don't think, Mr. DeBoos, that you have filed any kind of demand or request or notice for jury trial. Have you?
I thought that was entered into the last court session.
Well, I don't think you filed any motion. You told me you apparently you told me you wanted a jury trial, but you never followed through.
I thought that was a decision that we made as the court.
Well, you and I did not make a decision of any kind. Mr. Patterson, do you believe it's acceptable for him to just say he wants a jury trial?
Your Honor, pursuant to case law, because there are at least up to 1 year in the county jail possible, if it's ever consecutive, then case law would state that he has a right to a jury trial.
Agreed, but does he not need to put something in writing to that effect that he wants one? That was my question.
Because there's an absolute right to jury trial.
And there it is, the oath demand. Sovereign citizens love to challenge judges to recite their oath of office, believing that refusal somehow invalidates authority. But that's pure fantasy. Every judge takes their oath upon appointment. It doesn't need to be redeclared in every case like a magic spell. Judge Webster's quick refusal. No, sir, I will not. Shows she knows this game. The goal here isn't clarification. It's disruption. But Webster won't give him the stage. She immediately moves on, keeping control. This exchange sets the tone. She's not engaging in performance. She's running court.
He would not have to put it in writing. It would have to be specifically waived by him, Your Honor. And I don't think he's done a waiver.
Very well. Do you agree with that, Mr. Regier?
Your Honor, what I can say at this time is pursuant to KSA 6238 subsection B, quote, on any issue or trial by right by a jury, a party may demand a jury trial by serving the other parties with a written demand, which may be included in a pleading no later than 14 days after the last pleading directed to the issue is served, and found the demand in accordance with KSA 6205 and amendments thereto.
Mr. Patterson, in spite of that statutory language, do you think he needs to waive his right to jury trial? Did I hear that right?
Absolutely, Judge. Pursuant to case law, and I don't dispute the statute whatsoever, but there is certain case law that makes it a constitutional right to a jury trial if the sentence would be up to a year in the county jail. And in this case, consecutively, it could be up to a year, the longest possible maximum. So it would have to be waived by him, and he would not have to make anything in writing to receive that.
But you don't believe that case law overrules the statutory law, or do you?
This is a constitutional right we're talking about, Your Honor. It would trump the...
This is a surprisingly good teaching moment. Both the prosecutor and standby counsel dive into whether Deuce needs to formally request a jury trial in writing. On one hand, Kansas statutes require a written demand. On the other, case law affirms a constitutional right to trial by jury for offenses carrying possible jail time. In short, yes, the right exists. But yes, procedure still matters. Judges can't read minds or act on casual remarks. Deuce's failure to file the motion shows the downside of self-representation. You might know your rights, but without proper process, those rights can't be exercised correctly.
Patterson, when you say up to a year in the county jail, are you thinking if they were to be run concurrently, or consecutively versus concurrently?
That would be the longest possible sentence when you start running them consecutively, and that's what the case law would state.
Do you have your statutory site or your case law sites by chance? I know you didn't expect to pull them out.
It's not one I keep handy, but giving a short recess, I can find that.
Well, now before you go to that, now, Mr. DeBoos, do you have any idea what's going on here?
I as a common man, do not comprehend the legalese that you guys are using together. I can look up statutes and case law myself, and considering that this is dealing with a common right to all people under granted to us in restriction of government entities for the people itself, um, I comprehend that I have my right to jury trial, which I thank Mr. Patterson in his brief support towards this and towards me, um, towards my right to a jury trial, although I do not fully comprehend the legalese that is going on within the association between Jared Regier and yourself.
And here comes a state of Kansas corporation argument, a fan favor among sovereign citizens. They claim governments are private corporations and that legal names are contracts created without consent. It sounds dramatic, but it's pure pseudo-legal nonsense. If Kansas were truly a corporation, you could skip court like skipping a store refund. Yet, every time someone tries this defense, the result is the same. The law doesn't care about internet theories. What matters is jurisdiction and statute. Judge Webster's expression says it all. She's heard this 1,000 times and knows exactly how to handle it, with calm authority and zero reaction.
Well, Mr. DeBoos, the point is you do have the right to represent yourself, and you've told me you want to represent yourself, and I've asked Mr. Patterson to stand by, and you've already used him here for this purpose. So
Well,
here's
I
the thing,
object to your
Mr.
use.
DeBoos. No, let me talk now, Mr. DeBoos. Here's the thing. If you're going to represent yourself, you need to be able to make your own arguments. You need to be able to cite your own law. And if you cannot do that, you have the right to legal assistance, which is why Mr. Patterson is here. And you've already this quickly run into a legal snag that he's made the argument for you. Does it not make sense to you? And do you not want to have his legal assistance to let him represent you?
I do not wish to be represented by an attorney whose duty first is to the courts and not to their clients. And if we're speaking on rights in regards to laws and statutes, the arrest made on me by Deputy K. Barriquet was an unlawful arrest
All right.
for
Well, we're not going on.
22-2401.
Notice what's happening here. The attorneys are continuing their discussion as if Deuce isn't even in the room. That might look rude, but in reality, it's strategic. When someone repeatedly injects irrelevant or baseless claims, professionals keep the focus on legal procedure, not theatrics. The Deuce's insistence on redefining law and common rights might sound empowering to him, but it effectively sidelines his participation. This moment is a perfect case study in how sovereign citizen logic backfires. Instead of controlling the narrative, he's now an observer in his own trial, watching real lawyers debate the rules that actually matter.
You do want a jury trial. Are you ready to proceed on Wednesday, Mr. DeBoos?
May I ask that there be an extension so that way I may fully research the procedures of the administrative criminal law which you're trying to try me under?
Well, I'm not the administrative law judge. That is yet another procedure.
Although you are in an administrative court under the state of Kansas Corporation, correct?
I'm here in a criminal traffic trial, and I am not an administrative law judge. So here's what we're going to do. How much time do you want this continued for?
30 days or so seems to be a standard.
Well, my next available jury trial date would be October 2nd and 3rd. So
2024.
2024. So that's when I will continue this at your request to. I'll grant your continuance, but that's my next available date. And your pretrial will be September 30th, 2024. Do you have any objections to that? Do you have any legal authority that suggests that I reaffirm my oath for him? Do you have anything that says I should do that?
Judge, I'm afraid I've never researched that issue, never heard that issue.
All right. Well, same here. I do have my oath in front of me. Keep it handy, but I don't see the need to repeat that. It was good enough for the.
This part almost feels tragic. The judge is literally offering deuce-free legal support. An attorney who's already proven helpful, but pride gets in the way. It's a sovereign citizen trap, rejecting help because accepting it feels like submission to the system. But what's really at stake isn't ideology, it's his freedom. Judge Webster's tone shifts slightly here. You can hear her frustration underneath her patience. She's not arguing anymore. She's pleading for reason. Deuce's refusal shows the human cost of misinformation. People so deep into false legal theory that they'd rather lose and admit they're wrong. And there it is. Another day, another sovereign citizen tangled in their own contradictions. Judge Webster's professionalism shines throughout, guiding the hearing with patience and precision, even when the defense went off the rails. From questioning the court's legitimacy to refusing counsel, Deuce's arguments only highlight how misinformation turns legal systems into battlegrounds for confusion. The takeaway? Knowledge of the law beats internet theories every single time.